A U.S. state is a constituent political entity of the United States. There are 50 states, which are bound together in a union with each other. Each state holds administrative jurisdiction over a defined geographic territory, and shares its sovereignty with the United States federal government. Due to the shared sovereignty between each state and the federal government, Americans are citizens of both the federal republic and of the state in which they reside. State citizenship and residency are flexible, and no government approval is required to move between states, except for persons covered by certain types of court orders. States range in population from just under 600,000 to over 38 million, and in area from 1,214 square miles to 663,268 square miles. 4 states use the term Commonwealth rather than state in the full official names. States are divided into counties or county equivalents, which may be assigned to a local governmental authority but are not sovereign. County or county equivalent structure varies widely by state. State governments are allocated power by the people through their individual constitutions. All are grounded in republican principles, and each provides for a government, consisting of 3 branches: executive, legislative, and judicial. States possess a number of powers and rights under the United States Constitution, among them ratifying constitutional amendments. Historically, the tasks of local law enforcement, public education, public health, regulating interstate commerce, and local transportation and infrastructure have generally been considered primarily state responsibilities, although all of these now have significant federal funding and regulation as well. Over time, the U.S. Constitution has been amended, and the interpretation and application of its provisions have changed. The general tendency has been toward centralization and incorporation, with the federal government playing a much larger role than it once did. There is a continuing debate over states' rights, which concerns the extent and nature of the states' powers and sovereignty in relation to the federal government and the rights of individuals. States and the residents are represented in the federal Congress, a bicameral legislature consisting of the Senate and the House of Representatives. Each state is represented in the Senate by 2 senators, and is guaranteed at least 1 representative in the House. Members of the House are elected from single-member districts. Representatives are distributed among the states in proportion to the most recent constitutionally mandated decennial census. Each state is also entitled to select a number of electors to vote in the Electoral College, the body that elects the President of the United States, equal to the total of representatives and senators from that state. The Constitution grants to Congress the authority to admit new states into the Union. Since the establishment of the United States in 1776, the number of states has expanded from the original 13 to 50. Alaska and Hawaii are the most recent states admitted, both in 1959. The Constitution is silent on the question of whether states have the power to secede from the Union. Shortly after the Civil War, the U.S. Supreme Court, in Texas v. White, held that a state cannot unilaterally do so. States of the United States. The 50 U.S. states, along with state flag and date, each joined the Union. Governments. As sovereign entities, each of the 50 states reserves the right to organize its individual government in any way deemed appropriate by its people. As a result, while the governments of the various states share many similar features, they often vary greatly with regard to form and substance. No 2 state governments are identical. Constitutions. The government of each state is structured in accordance with its individual individual constitution. Many of these documents are more detailed and more elaborate than the federal counterpart. The Constitution of Alabama, for example, contains 310,296 words, more than 40 times as many as the U.S. Constitution. In practice, each state has adopted a three-branch system of government, modeled after the federal government and consisting of three branches: executive, legislative, and judicial. Executive. In each state, the chief executive is called the governor, who serves as both head of state and head of government. The governor may approve or veto bills passed by the state legislature, as well as push for the passage of bills supported by the party of the governor. In 43 states, governors have line-item veto power. Most states have a plural executive, in which two or more members of the executive branch are elected directly by the people. Such additional elected officials serve as members of the executive branch, but are not beholden to the governor, and the governor cannot dismiss them. For example, the Attorney General is elected, rather than appointed, in 43 of the 50 U.S. states. Legislative. The legislatures of 49 of the 50 states are made up of two chambers, a lower house and a smaller upper house, always termed the Senate. The exception is the unicameral Nebraska legislature, which is composed of only a single chamber. Most states have part-time legislatures, while 6 of the most populated states have full-time legislatures. However, several states with high population have short legislative sessions, including Texas and Florida. In Baker v. Carr and Reynolds v. Sims, the U.S. Supreme Court held that all states are required to elect their legislatures in such a way as to afford each citizen the same degree of representation. In practice, most states choose to elect legislators from single-member districts, each of which has approximately the same population. Some states, such as Maryland and Vermont, divide the state into single and multi-member districts, in which case multi-member districts must have proportionately larger populations, e.g., a district electing 2 representatives must have approximately twice the population of a district electing just 1. If the governor vetoes legislation, all legislatures may override it, usually, but not always, requiring a 2/3 majority. In 2013, there were a total of 7,383 legislators in the 50 state legislative bodies. They earned from $0 annually to $90,526. There were various per diem and mileage compensation. Judicial. States can also organize the judicial systems differently from the federal judiciary, as long as they protect the federal constitutional right of the citizens to procedural due process. Most have a trial-level court, generally called a district court, superior court of circuit court, a first-level appellate court, generally called a court of appeal, and a Supreme Court. However, Oklahoma and Texas have separate highest courts for criminal appeals. In New York State, the trial court is called the Supreme Court. Appeals are then taken to the Supreme Court's appellate division, and from there to the Court of Appeals. Most states base the legal system on English common law, with the notable exception of Louisiana, a former French colony, which draws large parts of its legal system from French civil law. Only a few states choose to have the judges on the state's court serve for life terms. In most of the states, the judges, including the justices of the highest court in the state, are either elected or appointed for terms of a limited number of years, and are usually eligible for re-election or reappointment. States as unitary systems. All states have unitary governments, and ultimately, local governments within each state are subject to the central authority of the particular state. State governments commonly delegates them authority to local units and channel policy decisions down to them for implementation. In a few states, local units of government are permitted a degree of home rule over various matters. The prevailing legal theory of state preeminence over local governments, referred to as Dillon's rule, holds that a municipal corporation possesses and can exercise the following powers and no others. First, those granted in express words. Second, those necessarily implied or necessarily incident to the powers expressly granted. Third, those absolutely essential to the declared objects and purposes of the corporation, not simply convenient but indispensable. Fourth, any fair doubt as to the existence of a power is resolved by the courts against the corporation against the existence of the powers. Each state defines for itself what powers it will allow local governments. Generally, 4 categories of power may be given to local jurisdictions: structural power to choose the form of government, charter and enact charter revisions; functional power to exercise local self-government in a broad or limited manner; fiscal authority to determine revenue sources, set tax rates, borrow funds and other related financial activities; personnel authority to set employment rules, remuneration rates, employment conditions and collective bargaining. Relationships among states. Each state admitted to the Union by Congress since 1789 has entered it on an equal footing with the original states in all respects. With the growth of states' rights advocacy during the antebellum period, the Supreme Court asserted in lessee of Pollard v. Hagan that the Constitution mandated admission of new states on the basis of equality. Under Article 4 of the United States Constitution, which outlines the relationship between the states, each state is required to give full faith and credit to the acts of each other's legislatures and courts, which is generally held to include the recognition of legal contracts and criminal judgments, and before 1865, slavery status. Regardless of the full faith and credit clause, some legal arrangements, such as professional licensure and marriages, may be state-specific, and until recently states have not been found by the courts to be required to honor such arrangements from other states. Such legal acts are nevertheless often recognized state to state according to the common practice of comity. States are prohibited from discriminating against citizens of other states with respect to the basic rights. Under the Privileges and Immunities Clause, under the Extradition Clause, a state must extradite people located there who have fled charges of treason, felony, or other crimes in another state if the other state so demands. The principle of hot pursuit of a presumed felon and arrest by the law officers of one state in another state are often permitted by a state. With the consent of Congress, states may enter into interstate compacts, agreements between 2 or more states. Compacts are frequently used to manage a shared resource, such as transportation infrastructure or water rights. With the federal government, every state is guaranteed a form of government that is grounded in republican principles, such as the consent of the governed. This guarantee has long been at the forefront of the debate about the rights of citizens vis-à-vis the government. States are also guaranteed protection from invasion, and, upon the application of the state legislature, from domestic violence. This provision was discussed during the 1967 Detroit riot, but was not invoked. Since the early 20th century, the Supreme Court has interpreted the Commerce Clause of the Constitution of the United States to allow greatly expanded scope of federal power. Over time, at the expense of powers formerly considered purely states' matters. The Cambridge Economic History of the United States says, on the whole, especially after the mid-1880s, the court construed the Commerce Clause in favor of increased federal power. Quote, in Wickard v. Filburn 317 U.S. 111. The court expanded federal power to regulate the economy by holding that federal authority under the Commerce Clause extends to activities which may appear to be local in nature but in reality affect the entire national economy and therefore of national concern. For example, Congress can regulate railway traffic across state lines, but it may also regulate rail traffic solely within a state, based on the reality that intrastate traffic still affects interstate commerce. In recent years, the court has tried to place limits on the Commerce Clause in such cases as United States v. Lopez and United States v. Morrison. Another example of congressional power is its spending power, the ability of Congress to impose taxes and distribute the resulting revenue back to the states. An example of this is the system of federal aid for highways, which include the interstate highway system. The system is mandated and largely funded by the federal government, and also serves the interests of the states. By threatening to withhold federal highway funds, Congress has been able to pressure state legislatures to pass a variety of laws. An example is the nationwide legal drinking age of 21, enacted by each state, brought about by the National Minimum Drinking Age Act. Although some objected that this infringes on states' rights, the Supreme Court upheld the practice as a permissible use of the Constitution's spending clause in South Dakota v. Dole 483 U.S. 203. Admission into the Union. Article 4, Section 3, Clause 1 of the U.S. Constitution grants to Congress the authority to admit new states into the Union. Since the establishment of the United States in 1776, the number of states has expanded from the original 13 to 50. Each new state has been admitted on an equal footing with the existing states. It also forbids the creation of new states from parts of existing states without the consent of both the affected states and Congress. This caveat was designed to give eastern states that still had western land claims to have a veto over whether the western counties could become states, and has served this same function since. Whenever a proposal to partition an existing state to states in order that a region within might either join another state or to create a new state has come before Congress. Most of the states admitted to the Union after the original 13 have been created from organized territories established and governed by Congress in accord with its plenary power under Article 4, Section 3, Clause 2. The outline for this process was established by the Northwest Ordinance, which predates the ratification of the Constitution. In some cases, an entire territory has become a state; in others, some part of a territory has. When the people of a territory make the desire for statehood known to the federal government, Congress may pass an enabling act authorizing the people of that territory to organize a constitutional convention to write a state constitution as a step towards admission to the Union. Each act details the mechanism by which the territory will be admitted as a state following ratification of the Constitution and election of state officers. Although the use of an enabling act is a traditional historic practice, a number of territories have drafted constitutions for submission to Congress absent an enabling act and were subsequently admitted. Upon acceptance of that constitution, and upon meeting any additional congressional stipulations, Congress has always admitted that territory as a state. In addition to the original 13, 6 subsequent states were never an organized territory of the federal government, or part of one, before being admitted to the Union. 3 were set off from an already existing state, 2 entered the Union after having been sovereign states, and 1 was established from unorganized territory. California 1850, from land ceded to the United States by Mexico in 1848 under the terms of the Treaty of Guadalupe Hidalgo. Kentucky 1792, from Virginia. Maine 1820, from Massachusetts. Texas 1845, previously the Republic of Texas. Vermont 1791, previously the Vermont Republic. West Virginia 1863, from Virginia during the Civil War. Congress is under no obligation to admit states, even in those areas whose population expresses a desire for statehood. Such has been the case numerous times during the nation's history. In one instance, Mormon pioneers in Salt Lake City sought to establish the state of Deseret in 1849. It existed for slightly over 2 years and was never approved by the United States Congress. In another, leaders of the 5 civilized tribes in Indian Territory proposed to establish the state of Sequoia in 1905, as a means to retain control of the lands. The proposed constitution ultimately failed in the U.S. Congress. Instead, the Indian Territory, along with Oklahoma Territory, were both incorporated into the new state of Oklahoma in 1907. The first instance occurred while the nation still operated under the Articles of Confederation. The state of Franklin existed for several years, not long after the end of the American Revolution, but was never recognized by the Confederation Congress, which ultimately recognized North Carolina's claim of sovereignty over the area. The territory comprising Franklin later became part of the Southwest Territory, and ultimately the state of Tennessee. Additionally, the entry of several states into the Union was delayed due to distinctive complicating factors. Among them, Michigan Territory, which petitioned Congress for statehood in 1835, was not admitted to the Union until 1837. Due to a boundary dispute, the adjoining state of Ohio, the Republic of Texas requested annexation to the United States in 1837, but fears about potential conflict with Mexico delayed the admission of Texas for 9 years. Also, statehood for Kansas Territory was held up for several years due to a series of internal violent conflicts involving anti-slavery and pro-slavery factions. Possible new states. Puerto Rico referred to itself as the Commonwealth of Puerto Rico in the English version of its constitution, and as Estado Libre Asociado in the Spanish version. As with any non-state territory of the United States, its residents do not have voting representation in the federal government. Puerto Rico has limited representation in the U.S. Congress in the form of a resident commissioner, a delegate with limited voting rights in the Committee of the Whole House on the State of the Union, and no voting rights otherwise. A non-binding referendum on statehood, independence, or a new option for an associated territory was held on November 6, 2012. 61% of voters chose the statehood option, while 1/3 of the ballots were submitted blank. On December 11, 2012, the Legislative Assembly of Puerto Rico enacted a concurrent resolution requesting the President and the Congress of the United States to respond to the referendum of the people of Puerto Rico, held on November 6, 2012, to end its current form of territorial status and to begin the process to admit Puerto Rico as a state. Washington, D.C. The intention of the Founding Fathers was that the United States capital should be at a neutral site, not giving favor to any existing state. As a result, the District of Columbia was created in 1800 to serve as the seat of government. The inhabitants of the district do not have full representation in Congress or sovereign elected government. Some residents of the district support statehood of some form for that jurisdiction, either statehood for the whole district or for the inhabited part, with the remainder remaining under federal jurisdiction. Others, various proposals to divide California, usually involving splitting the south half from the north of the urban coastline from the rest of the state, have been advanced since the 1850s. Similarly, numerous proposals to divide New York, all of which involve to some degree the separation of New York City from the rest of the state, have been promoted over the past several decades. The partitioning of either state is, at the present, highly unlikely. Other even less likely possible new states are Guam and the Virgin Islands, both of which are unincorporated organized territories of the United States. Also, either the Northern Mariana Islands or American Samoa, an unorganized, unincorporated territory, could seek statehood, secession from the Union. The Constitution is silent on the issue of the secession of a state from the Union. However, its predecessor document, the Articles of Confederation, stated that the United States shall be perpetual. The question of whether or not individual states held the right to unilateral secession remained a difficult and divisive one until the American Civil War. In 1860 and 1861, 11 southern states seceded, but following the defeat in the American Civil War were brought back into the Union during the Reconstruction era. The federal government never recognized the secession of any of the rebellious states. Following the Civil War, the United States Supreme Court, in Texas v. White, held that states did not have the right to secede and that any act of secession was legally void, drawing on the preamble to the Constitution, which states that the Constitution was intended to form a more perfect union, and speaks of the people of the United States in effect as a single body politic. As well as the language of the Articles of Confederation, the Supreme Court maintained that states did not have a right to secede. However, the court's reference in the same decision to the possibility of such changes occurring through revolution, or through consent of the states, essentially means that this decision holds that no state has a right to unilaterally decide to leave the Union. Commonwealths. 4 states, Kentucky, Massachusetts, Pennsylvania, and Virginia, adopted constitutions early in the post-colonial existence identifying themselves as commonwealths, rather than states. These commonwealths are states, but legally each is a commonwealth because the term is contained in its constitution. As a result, commonwealth is used in all public and other state writings, actions or activities within the bounds. The term, which refers to a state in which the supreme power is vested in the people, was first used in Virginia during the interregnum, the 1649–60 period between the reigns of Charles I and Charles II, during which Parliament's Oliver Cromwell as Lord Protector established a republican government known as the Commonwealth of England. Virginia became a royal colony again in 1660, and the word was dropped from the full title. When Virginia adopted its first constitution on June 29, 1776, it was reintroduced. Pennsylvania followed suit when it drew up a constitution later that year, as did Massachusetts in 1780, and Kentucky in 1792. The U.S. territories of the Northern Marianas and Puerto Rico are also referred to as commonwealths. This designation does have a legal status different from that of the 50 states. Both of these commonwealths are unincorporated territories of the United States. Origins of states' names. The 50 states have taken the names from a wide variety of languages. 24 state names originate from Native American languages. Of these, 8 are from Algonquin languages, 7 are from Siouan languages, 3 are from Iroquoian languages, 1 is from Uztecan languages, and 5 others are from other indigenous languages. Hawaii's name is derived from the Polynesian Hawaiian language. Of the remaining names, 22 are from European languages, 7 from Latin, the rest are from English, Spanish and French. 11 states are named after individual people, including 7 named for royalty and 1 named after an American president. The origins of 6 state names are unknown or disputed. Several of the states that derive the names from names used for native peoples have retained the plural ending of s.